Disclaimer, none of this is legal advice. If you do need legal advice, talk to a competent attorney or, as far as patents goes, a patentee. We're now moving to first to file, which is related to who gets a patent and how they get it. You file a patent application and the examiner cites something before you filed. You can't say, oh wait, I thought of it first. A person shall be entitled to a patent unless if the law had stopped there, then we would have had a genuine first-to-file situation. But it didn't. It put in a whole list of exceptions. I should point out there's a divergent point of view. And what these exceptions basically boil down to is if you made your idea public before you filed, you can go back to the date that you made it public.
So what would be the motivation for filing a provisional now that you can do this for free? Not that a provisional costs that much, but you could just simply take your provisional and publish it and then achieve this.
Right, but you would lose all your international rights to your idea. There's now another couple here that are related to patents. If you publish a paper, your paper can't be held against you for your own patent application, provided it wasn't more than a year ago. So, as you can see, there's some divergence in point of views as to what these exceptions cover, what they don't cover. And here's the process by which we're going to get some clarity over the next year and a half on what it means. The Patent Office is going to dive into some rulemaking. They're going to look at this law. They're going to create some rules on how this law is to be applied. Those rules will be posted on the Patent Office website. There will be a period of public commentary, and then the final rules will issue. After we have the rules, we have to write the manual. The manual of patent examining procedure will be the directions that the examiners all have to go by in applying the interpretations of this law. Then, within the different art units, like pharmacy and software and stuff like that, they'll further refine and give guidance to their examiners. When there's conflict, it will go up on appeal, and the decision will feed back here. And if Congress doesn't like the direction law is heading, they may change the law and make more exceptions or take some away or modify. Who's going to care about this? Well, I took some random samples of patent applications, published patent applications in different art units. It's sort of a spectrum of activity, if you will. And I looked at the patent applications, and I looked at what the examiner was rejecting them on. I said, well, how old is this prior art that's being cited against these patents? Because if they're less than a year old, then these exceptions may be applicable. Right? So if you're inventing a new type of wooden box, you really don't have to worry too much about this law because you're going to get 10-year-old art cited against you. And whether or not the exceptions apply